Peace and love, everyone. Let me get my phone going. Get my volume down. How's everyone doing? As you come in, you know the routine. Let me know if you can see me, if you can hear me. All right, put a 1 in the chat if you can hear me. Hello there. Hi, everybody. We back. We back for day 4. Day 4. All right, so you know the routine as you come into the room. Let me know if my video is good. Let me know if my audio is good. And let me back up a second. Welcome to day 4 of the Refine Your Status Revocable Living Trust Challenge. All right, I hope that everyone is doing well. As you come into the room, please drop your biggest takeaway from yesterday's lesson. We covered a lot of material, right? We covered a lot of material yesterday. Some of it was definitely a little mind-blowing, right? So from yesterday's lesson, what was your biggest takeaway? We spoke about the fact that your interest is your property. So I want you all to tell me, I'm looking at the chat, I want you all to tell me what your biggest takeaway was. Okay, my interest was my property. So other than that, your interest was your property, your interest is your property. What, any other major takeaways from yesterday's lesson? Any other major takeaways from yesterday's lesson? Peace and love, everyone. Peace and love to you. I'm hoping that those people who weren't able to catch the first 3 days are here. I did my best to make sure that the necessary emails had gone out, right? So that people knew where to go to participate in the challenge, because I think some people still were not clear on where to go to participate in the challenge. And I take full responsibility for that. Wasn't clear communication on the website. I guess I was just assuming that people would click on the link that was provided in the website to be able to access the challenge through this particular group. But I got an influx of emails of people asking for a link, right? So that tells me that my communication was not clear. And so for that, I do apologize. All right, so let me go back and look at what you all have as your biggest takeaway. So I hope that you all went back and completed the, the questions that were in the guide from day 3, right? I hope that you all went back and filled that out, because the guide is given to you as a resource. It's there for a reason, so you definitely want to use it to answer those, make sure you answer those questions, and then just take your notes, even if you have to flip the guide over onto the other side and take your notes. I just want to make sure that everyone has a clear understanding of what the lesson is. All right, so let's see what I see in here. Yes, the duality. The Most High operates in dualities. There is a public and a private side to everything that we see. Protection. Yes, we went over the importance of the protections as it relates to modeling the original trust model given to us by the Most High. We spoke about that dominion trust, right? I think we spoke about the dominion trust on day 2 or day 3. I'm sorry, y'all, I can't remember, but I know it was good. I know that it was good. All right, we must claim our property, our signature. Yes, yes, yes. When the trust is collapsed, there is no more values in the trust. That is absolutely right. That means that the values were transferred away to someone. Janice says your signature is your interest. Liz says debts are an asset by way of our signature. Kamaya says on the revocable trust, you can be the trustee, the beneficiary, and the settler. Okay, settler, grantee, settler, right? That we can deposit the SS person's debts as trust res, absolutely. The security interest claim is subordinate to the ownership interest claim. Yes. Yes, yes, yes. That is a good one. Angelique, that's a good one that we went over, because security interest and beneficial ownership interest is the very essence of the duality that we see between the public and the private, right? So legal is fiction. Okay, so anytime that you're dealing with security interest on the public side, that is specifically related to a legal title, a fictional title. All right, L.E. I'm so sorry if I'm mispronouncing your name. I am the source of all values and derivatives created by way of my signature. Yes. Russell says title merge. Yes. KB, grantee settler clarification. Sama, I learned that interest is more than what I actually thought it was, such as a security interest. Yeah, that's a good one. Angelique says the living trust is very flexible. It can be updated or collapsed at any time. Now that's the revocable living trust, right? That's the, make sure you emphasize revocable, because you have an irrevocable and you have revocable. Now you actually can have a irrevocable living trust on the private side, right? So you want to just remember that revocable is something that you can change at any time, right? Irrevocable, once it's created, you can't change it. All right. Lena says, my take away from yesterday's class is if we are the source of all value in the signature place, we have immediate interest nearing our signature on contract, land, world, nations. My interest is my property by way of signature, assets, principles. Yes, yes, yes. Angela says, we have to be able to use the principles of law when operating in trust. Yes. That is entirely true. Nefertiti says day 2. Angela, we must express our interest in our trust accounts. Mary, we have a plethora of interests. We have absolute interest over all assets. That is an important point to remember. Yes. Eddie says, must learn to be on the offense. Yes, must learn to be on the offense. That means that we have to initiate before they're coming after us for whatever their claim is, right? All right. Nefertiti says, I learned that I always want to be on the equitable title in everything. Absolutely. 100% absolute interest is superior. Our debts are assets. We must title merge. Yes, ma'am. Oh, yes, ma'am. Equitable side at all times. Express my interest on the ledger. Equitable and legal title. Nefertiti says you can absorb and collapse the trust into another trust. Absolutely, absolutely, absolutely. Yes, great takeaways, y'all. Y'all are doing so good. I'm so proud of y'all. I'm actually proud of y'all are learning. Y'all learning. Y'all got this thing. You are gonna be so good at this, because these are the principles that they're not necessarily being taught out there. They're not being taught. So it's important to look up definitions. You all know that I am huge on definitions. I know you hear me say that all the time, but the definitions are key to gaining the proper understanding and context of what's happening out here, right? Very, 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 very big on definitions, all right? So today is day 4, all right? I'm gonna ask y'all a question, because I wanna see if y'all are really thinking outside the box. Okay, I wanna ask y'all a question. Okay, y'all ready? Put a ready in the chat if you're ready. Are you ready? Are you ready? Are you ready? Let me see them readies. AB says, I have Black's Law Dictionary right in front of me. Yes, 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 yes. Okay, all right. Okay, so now we spoke about the grantee. All right, we spoke about the grantee. We're going to take that word and we're going to break it down. All right, so in one of the previous lessons, we specifically stated that EE receives and OR gives. EE receives and OR gives. I want someone to write that in the chat. EE receives, that's E as an elephant, E as an elephant, receives, OR gives. EE receives, OR gives. I want someone to write that in the chat for me so that we have it in the chat. All right, EE receives, OR gives. Yes, EE receives, OR give. Okay, so you have to ask yourself a question. Ask yourself a question. What specifically is being given and what is being received? I want you all to let me know what you think. What is being given and what is being received when you go and enter into a consumer credit transaction and you receive the contract from the lender, creditor, whomever, for you to sign. Okay. Russell says rights granted. Angelique says interest. Okay, I want you all to tell me what is being given and what is being received. Okay. Okay, we got interest, credit, interest, rights granted, credit, assets, assignment and transfer, property, rights to the proceeds, credit, interest. Okay, let's take it all the way back. Okay, so Angela says our securities is being given, our signature is being received. Okay, collateral, okay, credit, okay. Okay, I'm giving them the right to my Sesta KV trust. Okay, authority, okay. All right, let's break down the root word. Let's break the word, let's break down the word grantee. Let's break the word down. We're gonna break it down. All right. All right, Mary says transfer of energy. Okay, let's break it down for a second because we're gonna break this word down. Okay, I want someone to put in the chat, grant dash EE, grant dash OR. Put it in the chat. Put it in the chat for me. Grant E, grant dash EE, and grant dash OR. Okay, perfect. Now I want y'all to really look at this word. Like really look at it. Okay, I want y'all to really look at this word though. Because I get what y'all are saying. I hear you. I promise you, I hear what you're saying. You said credit, values, all this different stuff, right? Okay, I received that. I hear you. But I want y'all to look at this word. Look at the word. And don't overthink the word. What is a grant? What is a grant? No, I want you all to tell me what is a grant. What's a grant? Okay, bonds, bestow, money, gift, money, value. Okay, go deeper. What is a grant? What happens when someone receives a grant? A grant. What happens when someone receives a grant? Exactly, Angela, right there. Something that you don't have to pay back. Something that you don't have to pay back. Okay, but let's take it a step further. We're gonna go into blacks because I pulled the definition. Pull the definition. Let me see. I have it pulled up here. We gotta dig into this definition, right? Okay, right here. Okay. What does that definition say right there? For grantee. This is coming out of Black's Law Dictionary, Black's second. This is coming out of second version of Black's Law Dictionary. All right, so it says a person to whom a grant is made. Okay, but I'm still having an issue with this word grant right here, right? Because, okay, I hear you, but what is a grant? What is a grant? And let me scroll back. Mary says something that you don't have to pay back is usually a gift. Okay, so when you think about small business owners, they apply for a grant, the monies is usually received, they don't have to pay back the money, right? As long as they meet certain eligibilities or requirements, right? Let's think about it on the public side for a second. A grant is something that you don't have to pay back. When you go to school, you get a grant for school. You don't have to pay that money back, right? Is that fair enough? Is that fair enough to say? You ain't got to pay back the money. Okay. So let's look at the definition of what a grant is pursuant to Black's Law Dictionary. Okay, a generic term applicable to all transfers of real property. Okay, transfers of real property. And this is coming out of Black's second. A transfer by deed of that which cannot be passed by livery. An act evidenced by letters patent under the Great Seal. Granting something from the king to a subject. Are y'all, see, I think y'all probably gonna, I don't know if y'all gonna catch this. I don't know if y'all are gonna catch this, okay? An act evidenced by letters patent under the Great Seal, granting something from the king to a subject. Technical term made use of in deeds of conveyance of lands to import a transfer. All right, so we already went over the definition of lands, right? We dealt with lands on day 2. Did we not? Didn't we deal with land, the definition of land on day 2? All right. Now it goes on to say, though the word grant was originally made use of in treating of conveyances of interests in land. Here they are again talking about interest, right? Exactly. Land was nations, the world. That was the biblical definition of land. All right. Through the word grant was originally made use of in treating of conveyances of interests in land to denote a transfer by deed of that which could not be passed by livery, and of course was applied to only incorporeal hereditaments. Did I pronounce that right? Hereditaments. And has now become a generic term applicable to a transfer of all class of property, all class of property, all class of property. All right. So when we look at this definition a little deeper, especially with regards to, where is it at? I was just looking at it. Oh, no, I got more to read. I'm sorry. Okay. As distinguished from a mere license, a grant passes some estate or interest. Some estate or interest. Corporal or incorporeal. And the lands which it embraces can only be made by an instrument in writing under seal, I think we said that before, and is irrevocable when made unless an express power of revocation is reserved. All right, so what did we say before about expressing the trust up front? so that you don't fall into the trap of debtor creditor. It says unless an express revocation, an express power of revocation is reserved. Okay, a license is a mere authority, passes no estate or interest, whatever. Okay, made by parole, is revocable at will, and when revoked, the protection which it gave ceases to exist. Are y'all getting this definition? We're gonna read it. We're gonna read it one more time. We're gonna read it again because I want y'all to really, really think about this. A generic term applicable to all transfers of real property. Now, when we're talking about real property, we're talking about all property. You know how when you look at the legal description of a house, it says real property, right? But that definition of real is way more expansive than just a tangible asset. It includes tangible and intangible assets, such as interest, values. All right, a transfer of a deed which cannot be passed by library. We're gonna have to look this word up right here. Hold on, y'all. We have to look up library. Let me pull up my L version, because this version of Black's second. Actually, no, I'm sorry. I'm in Black's first. I thought I was in second. I'm actually in first. This is Black's first. This is actually Black's first. Let me pull the definition of library up, because we got to dig into these definitions. This is how you study. Okay, we're looking for Livery. Let me scroll down to LIV, because this is I have it in a PDF and it's separated according to letter. All right, so I'm down to LIV. Let me see. All right, so it's telling me that the term livery means delivery. This is it right here. Delivery of possession of their lands. Delivery of possessions of their lands. Okay. So a transfer by deed of that which cannot be passed by delivery of their lands, because you got to fill the definition with what the definition said, right? Replace the word with the definition. A transfer by deed of which cannot be passed by delivery of their lands. Okay, an act evidenced by letters, patent under great seal. Evidence by letters. So that tells you that it has to be written. There has to be some sort of agreement on the table. Granting something from the king to a subject. Okay, so let me ask you all a question, because today, remember, we're speaking about the real party of interest. We're speaking about the real party of interest, okay? Now, if you know that you are the source of all values, those values are your interest. Your interest is your property. Your property needs to be protected. And in that property, or in that interest that is your property, literally what's happening when you enter into a consumer credit transaction, you are receiving back the very values that you created. Are you following me? You're receiving back the very values that you created. Think about it for a second. When you go to sign an installment loan agreement, that installment loan agreement has no value until you sign it. So you literally created the money. You created the money. The bank gave you the contract for you to sign. They gave you your values in writing. They gave you a grant, and then you turned around and you signed the grant right back to them. You signed it right back over to them. Unknowingly signing away the very values that you created by way of that contract. You gave it right back to them, meaning you gave them a grant. You're going to continuously pay on this grant. You gave them the grant, so they're receiving the payment because you gave them the grant. Instead of doing what the definition says in terms of expressing your authority up front, we didn't express the authority up front. Where is it at? Right here. So let's back up. Where were we? Where is it at? Transfers of real property, conveyance of lands. Where was it at? Distinguished from a mere license, a grant passes some estate or interest. So you literally passed, yeah. You literally passed a portion of your estate to the creditor. You passed it to them. You granted it to them. You received it initially. They initially gave it to you, and then you turned around and gave it right back to them. So how was it that they're claiming to have the higher claim against you? How do they have the higher claim when you, in essence, created the value? You took a piece of your estate and you gave it away, literally gave it away. And corporal or incorporeal, that is tangible or intangible, right? Because we don't go to this definition. Corporal property. Corporal property. What does it say? It says right here, as distinguished from a mere license, a grant passes some estate or interest, whether corporal or incorporeal, in the lands which it embraces, can only be made by an instrument in writing under seal. Okay, so when we look up the definition of corporeal, I don't even know if I'm pronouncing that right. It says, such as affects the senses. This is some deep stuff. It may be seen and handled by the body, as opposed to incorporeal property, which cannot be seen or handled, and exists only in contemplation. It gives you an example. Thus, a house is corporeal, but the annual rent payable for its occupation is incorporeal. Corporeal property is, if movable, capable of manual transfer. If immovable, possession of it, possession may be given up, possession of it may be delivered up. But incorporeal property cannot be so transferred, but some other means must be adopted for its transfer, of which the most usual is an instrument in writing. I know you didn't know. And it's okay. Oh my goodness. This is what I know. Right. So remember, today we're talking about the real party of interest. These definitions should further solidify in your mind what actually is happening when you enter into a consumer credit transaction, right? And so you are the real party of interest. You just have to express it. You have to express it, and you have to prove it. You do have to prove it now, because you can't just write up some documentation saying I'm the real party of interest. Okay, but what evidence do you have? What evidence do you have? You have the evidence of your interest, okay, by way of your signature, but why is your signature evidence? Somebody explain to me why the signature is evidence that you are the real party of interest. And we went over this on day one. I want to see if y'all been paying attention. Why is the signature evidence that you are the real party of interest? Somebody tell me in the chat. We went over this on day one. Go deeper. Go deeper. We went over this on day one. Come on, y'all. What's the answer? Nope, not copyright. She said, because I asked for the loan. Nope, nope, nope. Why is the signature evidence that you are the real? Yes. KB, Mary, exactly. Because you're the source. Because you are the source. Because you're the source, not because you asked for the loan, not because it's a derivative. Yeah, well, yeah, we know it's a derivative, but in essence, you are the source. You are the creator. You are the creator. You are the creator. Because with you, there is no money. Nothing happens without you. Absolutely nothing happens without you. So when you go and you express yourself in your paperwork, what is one of the things that you're going to say? How in the world am I liable for this when I'm the source of all values? I am the source that created this derivative. This derivative is an extension of me. It's a derivative of you. That's it. That's all you got to remember. You're the real party of interest. You have a superior claim to everybody out there. Anything having to deal with your signature, the birth certificate, or the SS individual, you are the real party of interest as grantee settler. You decide, you give instructions to the trustees on how to deal with trust res. That's you. All right. You assign your beneficial interest if you so choose. That is you. You are in control. Don't let these people think that they're in control. You are actually in control. All right, I had another definition up here for you all: equitable versus legal, because we're talking about interest, right? Now, this is 6. You know, like I told y'all before, if it's not a young edition, the definitions are watered down. But this was definitely a good one to sort of kind of look at, even though the definition is a little bit off. It is a little bit off. Equitable versus legal. That's the duality of what we've been talking about, right? The idea is to have, and I want you to write this down, because I'm about to give you this. I want you to write this down. I want you to write this down. Y'all got y'all pens ready? Write this down. The idea is to have ownership, equitable ownership, without legal responsibility. You want to have equitable, beneficial ownership without legal responsibility. You want to be able to enjoy the benefits of ownership, but not have the liability of ownership. That's really what I needed to say. You want to enjoy the benefits of ownership without the liability of ownership. Somebody write that in the chat. You want to enjoy the benefits of ownership without, how did I say it before? See, I lost it. You want to enjoy the benefits of ownership without the liability of ownership. Okay, I'm going to write it in here for y'all. That's what we want. That is the ultimate kingly, rightful position. You want to enjoy the benefits of ownership without the liability of ownership. That means that you still get the car, you still get the house because you are equitable beneficial owner, but you don't got to pay no bills. You don't have the legal obligation to pay. That is the highest possible position that you can be in with in terms of how it relates to a trust. You want beneficial ownership. You want the benefits of ownership without the liability of ownership. Because basically what that means is that legal title is held with another. You're enjoying the equitable side of the ledger where legal title is held by another. That is the position that we want to be in. So this is how you want to be able to approach your accounts. You have to express this because you're the source of all value. The liability is on them, not on you. You elevate yourself to a higher position where you can enjoy the benefit without the obligation to pay because you are the source. Exactly. That's right. We are moving up with the Most High. Yes. So that's your takeaway for today. You are the real party of interest. All right. So y'all know y'all got to give it to me, right? Come on and give it to me. Come on in the chat. I am the real party of interest. I am the real party of interest. I am. I am. I am. I am the real party of interest. We got 26 people on the call. Everybody typing in the chat. I am the real party of interest. I am the real party of interest. I am the real party of interest. Yes. I'm the real party of interest. Beautiful, beautiful, beautiful. Yes. Yes, yes, yes. That's right. That's what you got to remember. Remember that you are the real party of interest and nobody can take away your beneficial interest unless you don't express it. I am the asset. Absolutely. Absolutely. Can you imagine if the world just woke up to these principles overnight, the type of change that would happen in this world? We literally could stop participating in capitalism just like that, just that fast. I want y'all to remember these lessons because this is important. Remember, it's gonna cause you to look at things a lot differently out here when you're operating in commerce. Anything that you put the signature on is your property. If you put your signature on something and somebody refuses to give it back to you, that's your property. You do know that you can file charges for that. Seriously though. Yeah, the powers that be will be very, very mad. Yes, a complete assurity, complete equity. All right, y'all. So that concludes today's lesson. Make sure you come back tomorrow for day 5, the finale. We're almost done. We're at the finale. We're at the finale. Yeah, you can definitely enforce by fee schedule, but see, the thing is, whatever you put in your documentation, you have to be able to prove. You got to be able to prove it. So if you're stating if you are citing fraud, you have to be able to prove the fraud. If you're stating that they use your signature without permission, how do you know? The evidence do you have to be able to prove whatever it is that you put in your document. You have to be able to prove that. Got to be able to prove it. Got to be able to prove it. And the thing of the matter is we want to begin to move in a direction of dealing with exclusive equity, because the at-law side, that's their stuff. That's their laws, their codes, their statutes. We want to deal with exclusive equity. All right. And a 100% beneficial owner, grantee, settler deals in exclusive equity. All right. All right. So peace and love, everyone. I hope that you all have enjoyed this lesson. Come back tomorrow for day 5 of the Refine Your Status Revocable Living Trust Challenge. I appreciate you all stopping by. I hope that this information is beneficial to you, that you're learning some principles by which you can begin to operate in commerce. I'm signing off for today. My name is Tamara T. Bush, and I will see you all on day 5. Deuces. Peace and love, everybody.